Good morning, Attorney Griggs.
Morning, my brother. How you doing?
I'm doing well, man. I'm doing well. So, obviously, you were in the courtroom yesterday, the hearing between the state and Harrison Floyd, one of the defendants in the case against, I guess, Donald Trump, and the issue being DA Fani Willis wanted to revoke Mr. Floyd's bond because she thought that there were some things online that kind of violated his conditions.
I stated on the record, he can say whatever he like on any post he like about me. I have no value for what he says, and I'm threatened every day anyway. So that he posts and I get threatened for more, that'll be what it is. I've learned to live with that, and I am a public official, and voters elected me here, and I put myself in this position. That does not give him the right to contact co-defendants or to intimidate other witnesses.
Tell us about what you witnessed yesterday.
Yeah, so yesterday there was a bond revocation hearing in Judge McAfee's courtroom. DA Fani Willis was actually presiding and representing the state, and Harrison Floyd was represented by his attorneys. And the crux of the issue was many social media postings, particularly on X, that Mr. Floyd had been doing vociferously, tagging the DA, tagging Brad Raffensperger, tagging the deputy Secretary of State, Gabriel Sterling, and others, basically voicing his displeasure with his charges and attempting to subvert the will of justice. And I was there as the president of the Georgia State Conference because there have been allegations that civil rights are being violated, both on the state side and on the defense side. And so I wanted to be there to witness what was happening. But our main concern from the Georgia NAACP standpoint is the continued threats that are being leveled at two Black poll workers, Ruby Freeman and Shade Moss. We are concerned about that and concerned about the attempts to subvert the will of the electorate from the 2020 election. And so we wanted to make sure that people's civil rights were protected and that this was a fair hearing. We think that the judge split the baby.
Under the terms of this order, he can do it without mentioning co-defendants, witnesses, or unindicted co-conspirators. So it'd have to be in broader terms. If we can fashion language that is more of a carve-out, we'll work on that.
Basically, he said that the comments that were made by Mr. Floyd did not rise to the level of a revocation, even though technically he had violated his bond conditions. And so the judge wanted to change the bond conditions so that it was clear to Mr. Floyd that if he does certain things that go over the line, his bond will be revoked. And like many people know in Georgia, once you're charged with a crime, many of your civil rights can be limited, whether that's the First Amendment right to speech or the Fourth Amendment right to search and seizures, because you have now been indicted and are accused of several crimes. And so there's a limitation to speech and a limitation to search issues once you've been charged.
Found it very interesting that the defense attorneys acknowledged that their client, Mr. Floyd, he actually went as far as he could go. He went up to the line, they said, regarding his use of free speech. They understand that his words have an adverse effect on these two young ladies that you were talking about. And I don't understand why the defense was arguing at all about what he should or shouldn't say, because as an attorney, I'm sure you have clients that when they're charged with a crime, basically you want them to be quiet, right? You don't want them online talking about this and that and the other, because these things could be used against them, as we saw yesterday.
Quite frankly, it's really in the defendant's interest to shut his mouth about this case because it can and will be used against him.
So I don't even understand why there was any back and forth relative to what he can and can't say, when in fact he should just be quiet.
Yeah, and I agree, and most competent defense attorneys would agree that your client should remain silent and should allow the lawyers to be the ones making the arguments. But in this new age of social media, we have clients that want to get their voice heard, and that's a righteous feeling. But when you're charged with felonies that could land you in prison for decades, you might want to listen to the voice of your competent legal counsel. And Mr. Floyd has to understand that there are two realities. There's the reality of social media, and then there's the actual reality of a Georgia courtroom. He came within a whisker of losing his freedom based on his perception of what he can and cannot say on X. X is not reality. Reality is those four walls that we were in yesterday with 8 deputies and all the members of law enforcement and the press, and the fact that Harrison Floyd, only because the judge said that these consent bonds were crafted while the judge was in the middle of a murder case and did not get a chance to address the defendants directly, is the only reason why he's not in custody. So I think that this was a wake-up call for Mr. Floyd and others that were present. I do know that there were some members of MAGA that were there. Y'all need to understand that in a Georgia courtroom, it's real easy to lose your freedom based on things that you say that threaten people. It's not free speech to threaten people. It's not free speech to try to get harm done to folks because you want impressions and clicks. There are real life ramifications. Ruby and Shay Moss should not be living in fear because they simply did their job. And so I think that this was a message. I don't ever want to see anybody locked up or their freedom taken away, but I also don't want to see people's lives adversely affected by the misinformation that is rampant on these platforms. So I think the judge made the right decision yesterday by giving him one more chance, but also being clarion clear that there are certain things that should not be said. Now, it's up to his legal counsel to come off of Twitter and focus on the case before them. I heard some things in that courtroom yesterday that disturbed me. How is it that you have discovery and you haven't read the discovery? How is it that you don't know who a witness is or what a witness might say when the state has already turned this stuff over? So as a defense attorney, I have some concerns about the level of representation, but hopefully, they're just getting up to speed. This is a major RICO case. Fonnie Willis is a very, very good prosecutor who's very experienced in RICO cases. I think the defendants need to focus on the cases and less on what's going on Twitter or X.
He meaning Harrison Floyd, he dodged the bullet yesterday, for sure.
Yes.
Now, after he realized that he wasn't going to jail, there was an exchange between Fonnie Willis and the judge where she acknowledged the defendant, Donald Trump, as defendant Trump. And he, Mr. Floyd, said, no, President Trump. And the judge had to step in and say, Mr. Floyd, you're not being spoken to.
I believe this is in defendant Trump's motion, if you want to pull it as part of your record.
President Trump.
Mr. Floyd, it's not your turn.
Now, this guy to me, he just oozes arrogance. Like he just wants to do his thing his way. He has to remember, man, he is not Donald Trump. And he doesn't have that same protection that Donald Trump has.
Yeah, I think all of the defendants need to realize this. And I think former President Trump, let's be clear with his title, he's the former president of the United States. He's not the current president. Need to understand that in a courtroom in Georgia, it doesn't matter what title's in front of your name. The only thing that matters is what 12 citizens say about whether or not you committed the allegations in front of you. I think they need to focus on that. They need to focus on the fact that there seems to be quite a bit of evidence against them that they tried to subvert the will of the voters in Georgia, and they are now charged with a RICO conspiracy. Currently, Ms. Willis has not lost a RICO case, period. And so I think they need to focus on the fact that she yesterday, on a scale of 1 to 10, was at an 8. I've dealt with Ms. Willis on numerous occasions. When she's that focused, it's usually detrimental to the defendant. So I wouldn't be going back and forth with Ms. Willis, especially when she's not speaking to you about the merits of what name she calls defendant Trump, because that's what the state of Georgia calls him now. He is defendant Trump. And so I think Mr. Floyd needs to recognize this is not Twitter. It's not X. It's not any of these social media platforms. This is real life. This is real court. And if you're not real careful, you will spend a lot of real time in the Department of Corrections in Georgia.
ironically, the day that Donald Trump was being arrested, we caught him on camera when he was about to turn himself in, and the deputies wouldn't let him turn himself in for some technical reason. I think he was supposed to go to the courthouse first before he went there. He was supposed to have some kind of deal done prior to that.
Yes.
Leave him alone. Let's go. He can turn himself in without a bump.
Now I can turn myself in?
Come on.
Now I can turn myself
Yes.
in? All right. But before you told me I couldn't, right? I had to go talk to the district attorney's office? That's what you said, right?
Yes, I did.
Okay.
Yeah, I think that people need to understand that there's a certain, it's not subservience that you should have for the criminal justice system, but it's a respect that at any given time, it can take away your freedom for a substantial amount of time if you're not careful. I think that his lawyers need to do a better job of controlling their client, getting him to understand that this is very serious. This is not a fraud. This is not fake. There were citizens of the grand jury that indicted you. And now it's time for a trial jury to determine whether or not there's proof beyond a reasonable doubt that you did exactly what they say you did. And his concern should be how this is coming across to the citizens of Fulton County, because those are the individuals that are going to decide whether or not you committed a crime in the state of Georgia in Fulton County. So it's incumbent upon his lawyers, and I only think that one of them is actually a licensed lawyer in Georgia, but they need to understand that they have to rein this in immediately, because playing for the cameras, playing to some audience that is on social media will get you a lot of time in a Georgia Correctional Institute. So again, as the Georgia NAACP, we just want to make sure that people's constitutional rights are being protected, and that witnesses are not being intimidated or attempts to harm anyone. Any of the things that we've seen based on the activities of this gentleman and others that are accused through their social media platforms of inciting things in the state of Georgia. Is having tried cases against Fonnie and have known Fonnie for a long period of time. When you see her at that level, you should be very concerned, because she's going to use all of the power of her office, which is immense, to make sure that the rule of law is upheld. And if you're on the other side of that, typically folks end up in prison for a long period of time.
Attorney Griggs, I appreciate you taking this day, the day before Thanksgiving, to come and talk to us. You're always on the cutting edge of all of these issues, and we so appreciate your efforts.
Well, thank you for having me on the platform, and I look forward to continuing to fight for the rights of Georgians and to make sure people's civil rights are protected.
All right. We'll see you on the other side.
Thank you, brother.